This is Barry Zalma, Zalma on Insurance. Today I'd like to speak about the False Claims Act and the Qui Tam suits that can arise as a result of insurance. The False Claims Act, also known as the Lincoln Law, dates back to the Civil War. President Lincoln signed the act into law in 1863 because war profiteers were selling the Union Army shoddy supplies at inflated prices. The original law included Qui Tam provisions that allowed a private person, a plaintiff, to sue those who defrauded the federal government. If the suit was successful, the plaintiff would recover 50% of any recovery from the defendant. The Qui Tam provisions were weakened greatly as a result of congressional amendments in 1943, and Qui Tam legislation became virtually non-existent. However, in 1986, Senator Charles Grassley, a Republican from Iowa, and Representative Howard Berman, a Democrat from California, joined forces to amend the law and strengthen the incentives for citizens to uncover and fight fraud as Qui Tam relators. Relators are the private plaintiffs under the False Claims Act. The 1986 False Claims Act amendments received widespread bipartisan support and were signed into law by President Reagan. Since the revitalization, the Qui Tam provisions have increasingly been used. The False Claims Act makes it unlawful to knowingly present or cause to be presented to the United States a false or fraudulent claim for payment or approval. Because there are many pseudo-insurance contracts issued by the United States, such as the flood insurance program, the crop insurance program, Medicare, and Medicaid, Qui Tam lawsuits seem to be progressing with a great deal of alacrity against those who work to defraud these government insurance programs, among other kinds of government programs. As an incentive to bring suit, a prevailing relator may collect a substantial percentage of any funds recovered for the benefit of the government. To establish civil liability under the False Claims Act, a relator generally must prove, 1, that the defendant made a statement in order to receive money from the government, 2, that the statement was false, and 3, that the defendant knew the statement was false. The Supreme Court of Pennsylvania set out the basics of the Qui Tam action in Marger v. Bultana, a 2002 decision of the Pennsylvania Superior Court, which held and stated, quote, "The False Claims Act permits the federal government to recover damages and penalties against persons who knowingly submit false or fraudulent claims to the government for payment or approval. In addition, the Act authorizes a private citizen to commence and prosecute a civil action on behalf of the United States. The purpose of the Qui Tam provision of the False Claims Act is to encourage private individuals who are aware of fraud being perpetrated against the government to bring such information forward. If the action is successful, the individual initiating the action is entitled to a portion of the recovery. The Act sets forth the following procedure for Qui Tam actions. The relator must file the complaint in camera and serve the government with the complaint and written disclosure of substantially all material evidence and information. The government then has 60 days to decide whether to proceed with the action. If the government decides not to join the action, the relator has the right to conduct the action on the government's behalf. The government may, however, intervene at a later date upon a showing of good cause. If the government does intervene, it assumes primary responsibility for the prosecution of the case and is not bound by any act of the relator. The relator remains as a party to the action, however, subject to certain limitations set forth in the act. Specifically, the government may dismiss the action notwithstanding the objections of the relator, provided, however, that the person has been notified by the government of the filing of the motion and the court has provided the person with an opportunity for a hearing on the motion. Most Qui Tam actions seek to recover damages and statutory penalties for false claims made to the government by government contractors, such as defense contractors and healthcare providers. A Qui Tam action can be brought for any government insurance program, such as National Flood, Medicare, and state-sponsored earthquake or storm insurance. However, a Qui Tam action cannot be brought against insurers based on their claim handling practices. Similarly, in State of California versus Unum Provident Corp., the insured and appellant sought to assert an 1871.7 claim, California's state insurance fraud Qui Tam statute, against a disability insurer. The Court of Appeal held that an insurer is not subject to a Qui Tam action under Section 1871.7 based on its marketing and claims handling practices. As Unum Provident explained, taken as a whole, Section 1871 et sec is specifically tailored toward preventing and punishing the making of fraudulent claims to insurance companies. While originally limited to the workers' compensation context, Section 1871.7 was amended in 1994 to extend its applicability to crimes involving fraudulent claims against insurers. Section 1871.7 subdivision B was designed to encourage insurers to bring Section 1871.7 actions. The court said, quote, Penal Code Sections 549 and 550 are tools to combat insurance claims fraud perpetrated against insurance companies, and any person who engages in such insurance claims fraud is the proper subject of a Qui Tam action under Section 1871.7. To interpret the statute in the manner urged by the appellant would improperly alter the statutory scheme to enlarge its scope, close quote. California Penal Code Section 550, subdivision B, penalizes those who present or cause to be presented any written or oral statement as part of or in support of or opposition to a claim for payment or other benefit pursuant to an insurance policy, knowing that the statement contains any false or misleading information concerning any material fact. It also makes it improper to prepare or make any written or oral statement that is intended to be presented to any insurer or any insurance claimant in connection with or in support of or opposition to any claim or payment or other benefit pursuant to an insurance policy, knowing that the statement contains any false or misleading information concerning any material fact, close quote. Section 550 is the California Insurance Fraud Act and makes it a felony to either attempt to or successfully defraud an insurer. Since the Qui Tam provisions were added to the Act in 1986, the U.S. Department of Justice calculated that the government has recovered more than $1.09 billion in Qui Tam cases, with whistleblowers receiving 18% or nearly $184 million of the government's recovery. When considering a Qui Tam action, be certain, however, that the authorizing statute authorizes the action. Allstate Insurance Company filed a Qui Tam action on behalf of itself and the state against defendants under the California Insurance Fraud Prevention Act, starting at Insurance Code Section 1871.1 and the Qui Tam Section 1871.7. Following entry of the Qui Tam judgment, Allstate began efforts to collect it. During its investigation, Allstate learned of a series of real estate transactions conducted by the defendants designed to transfer away their assets. Allstate, on behalf of the state, filed an action to set aside the fraudulent transfers of real and personal property. Allstate subsequently obtained a stay of the fraudulent conveyance action and returned to the Qui Tam court, where it filed a motion for an order allocating the Qui Tam judgment proceeds. The motion was based on a stipulation entered into between the people and Allstate, allocating to Allstate 50% of the civil penalties and assessments plus reasonable attorney's fees and costs. The trial court granted Allstate's allocation motion and entered the stipulation as a judgment. The defendants, of course, appealed. The court held that the judgment debtor defendants in Qui Tam insurance fraud actions are not aggrieved by such allocation orders under Section 1871.7, with the result that they do not have standing to appeal. In People ex rel Al-Zayat versus Heb, a 2017 decision of the California Court of Appeal, the court held that as a true Qui Tam provision, Insurance Code Section 1871.7 does not mandate that the relator has suffered his or her own injury. The court further noted that the lawsuit under Section 1871.7 was based on an injury allegedly suffered by the people of the state of California and was not filed for the purpose of remedying an injury suffered by the relator. The act follows directly on the California statute, and Heb supports a finding that Act claims are not restricted only to insurance companies or individual relators who have been personally injured. If an individual has knowledge that a false claim was submitted to the government, that person can elect to become a whistleblower and retain an attorney who will draft a complaint and a disclosure statement. The whistleblower will file these two documents under seal in U.S. District Court and send copies to the Department of Justice. And after the complaint is filed, the Justice Department has 60 days to investigate the allegations and determine whether it will join the suit. The False Claims Act states that any person can file a Qui Tam action as long as they have direct and independent knowledge of the fraud, and this knowledge was not obtained from a public disclosure. The definition of person includes not only individuals, but also businesses and state or local government entities. The most common plaintiffs in Qui Tam actions are employees of government contractors, healthcare organizations, and local, state, or federal government. The question that is raised every time a Qui Tam action is filed is why the U.S. and its various federal police entities and the U.S. Department of Justice did not bring the action itself and act proactively to defeat fraud against the government. Every 2 years, politicians claim they will fund various projects by eliminating fraud and abuse, only to do little or nothing to defeat fraud and abuse. Obamacare is a perfect example of where the funds to run the anti-fraud work seems to, by statute, reduce every year after Obamacare was enacted. This video was adapted from my book, Zalma on Insurance Claims, Part 109, Second Edition, which is the 9th part of a 10-part treatise, Zalma on Insurance Claims, all of which are available as both Kindle books and paperbacks from Amazon.com. If you found this video to be useful or interesting to your colleagues, please pass it on. It's free. And please also subscribe to my Rumble channel, my YouTube channel, my blog, and my Substack articles so that you can be informed of future videos and future postings. Thank you for your attention.